Discretionary power, balancing the rule of law. The exercise of power in the modern state necessitates a degree of flexibility encapsulated in the concept of discretionary power. This power, inherent particularly in the executive and administrative branches, involves the right to make a choice between various possible courses of action, especially when the law does not dictate a specific outcome. While discretion is lauded as an inevitable tool for good governance, offering the requisite agility to handle complex modern issues like public debt control or policing, its very nature, the freedom from rigid rule, places it in fundamental tension with the rule of law. The rule of law mandates that governance must be by clear, predictable legal rules, rather than the arbitrary will or personal ends of officials. Achieving a functional government thus demands a careful and constant effort to strike a delicate balance between administrative necessity and the foundational principles of legality and control. Discretionary power, recognized since ancient times as a means of correction of the law, is foundational to the administrative state. Given the vast, complex, and rapidly evolving landscape of public life, including health, environment, and social services, the legislature lacks the capacity to enact laws covering every possible detail or emergent scenario. Consequently, authorities must be granted the capacity to select an option between multiple solutions, determining the whether, when, how, and what of governmental action. The complexity of public administration tasks, such as managing public debt reduction while securing constitutional rights and maintaining balanced budgets, requires flexible implementation tools that go beyond specific statutory rules. However, the inherent flexibility of discretion carries the risk of abuse. The broader the discretion conferred, the greater the opportunity for its misuse, arbitrariness, or capricious application. Historically, widely differing attitudes have existed regarding the proper quantity and quality of discretion. Yet the consensus holds that discretion, even if considered a necessary evil, must be accepted but also properly regulated. Abuse of power is serious, often involving officials knowingly taking into account private interests or non-legitimate factors rather than the public interest. The core challenge, therefore, lies in establishing controls that prevent the abuse of discretion without unduly hindering the ability of officials to perform their necessary functions effectively. The rule of law serves as the constitutional boundary, ensuring that power is exercised legitimately. At its heart, it insists that questions of legal right and liability should ordinarily be resolved by application of the law and not the exercise of discretion. To constrain governmental power, the rule of law emphasizes principles such as the accessibility, clarity, and predictability of the law, as well as the principle of equality before the law. This concept is inextricably linked to the separation and balance of powers, the constitutional framework designed to prevent the accumulation of all powers in one hand, which is defined as tyranny. This framework demands mutual control mechanisms so that no one branch can arbitrarily exercise functions specific to the others. The rule of law requires that officials exercise powers conferred on them in good faith, fairly, for the purpose for which they were conferred, without exceeding their limits, and not unreasonably. In the judicial realm, the philosophical debate surrounding discretion further defines the rule of law. Positivist thinkers asserted that in hard cases, where the law is unclear, judges must use discretion because there is no legally required solution. Conversely, Ronald Dworkin argued against this, suggesting that a thorough investigation of legal standards would often reveal a unique solution, implying that law should guide decisions even in controversial cases. Under a modern interpretation, the rule of law is seen as the ascendancy of a culture of argumentation focused on antecedent legal materials and professional reason-giving, thereby insulating decision-making from political advantage or self-interest. The fundamental principle underwriting the balance is that there is no unfettered or unlimited discretion. Courts have established restrictive principles to constrain even the widest conferral of power. This control is achieved through three primary mechanisms: legislative, administrative, and judicial controls. Legislative control occurs pre-conferment by laying down the framework, conditions, and explicit boundaries. Post-conferment, administrative control, often referred to as structuring discretion, is crucial. Public officials channel broad statutory grants into narrow streams by laying down internal guidelines, procedures, and policies to ensure transparency and uniform application. This includes the development of open plans, rules, policies, and recorded reasons for decisions. Structuring helps prevent abuse and generates a system where all parties can reasonably expect that discretion will be exercised within defined limits. Judicial review is the principal mechanism used by courts to police the lawfulness and fairness of public actions. The judiciary does not substitute its judgment on the merits of the decision, but reviews the process by which the decision was made. Common grounds for challenging administrative discretion include illegality, irrationality, and procedural impropriety. Illegality covers acting ultra vires, beyond conferred powers, taking into account irrelevant considerations, disregarding relevant considerations, or exercising power for an improper purpose. It also covers the impermissible fettering or delegation of power. Irrationality is known primarily through the Wensbury test. A decision can be quashed if it is so outrageous in its defiance of logic or accepted moral standards that no sensible person could have arrived at it. Procedural impropriety is based on principles of natural justice, requiring the decision-maker to be impartial, the rule against bias, and providing the right to be heard. Good administrative practice also requires the provision of reasons for decisions, promoting accountability, consistency, and public confidence. A vital ground for judicial review, increasingly replacing or supplementing traditional unreasonableness tests, is the principle of proportionality. Proportionality dictates that a public authority must maintain a sense of proportion between its objectives and the means employed to achieve them. It requires scrutiny to ensure that the administrative action is balanced and reasonably related to the purpose of the conferred power. Proportionality testing, especially in jurisdictions with codified human or fundamental rights, involves a heightened scrutiny. It asks whether the means employed were suitable to the legitimate aim, whether a less restrictive alternative could have achieved the aim, and whether the restriction is justified overall. The correlation between proportionality and legality is profound. A violation of proportionality often implies overcoming the freedom of action permitted by law, thus constituting an excess of power. For instance, in criminal sentencing, mandatory minimum penalties are widely criticized precisely because they remove judicial discretion necessary to apply proportionality, forcing the imposition of sentences heavier than required by the justice of the case and undermining the rule of law. Discretionary powers are a fundamental, unavoidable feature of the modern democratic state, essential for efficiency, flexibility, and meeting the complex demands of governance. Yet, if unchecked, they risk leading to arbitrary rule and corruption, substituting the rule of men for the government of laws. The sources demonstrate that the balance is achieved not by eliminating discretion, but by subjecting it to stringent and multi-layered controls. The legislative and administrative bodies must actively structure discretion with clear guidelines, objectivity, and fairness. Ultimately, the legitimacy of discretion rests upon the judiciary, which, through judicial review and the application of evolving doctrines like illegality, unreasonableness, and proportionality, ensures that the inevitable freedom of choice granted to officials remains strictly bounded by the enduring requirements of the rule of law.